Starting with the fourth point, that is, an offer must be distinguished from a quotation or an invitation to an offer. The fourth point says as that, so whenever there is an offer, there is a variation between an offer and an invitation to an offer. So you need to understand the variation between an offer and an invitation to an offer. So we'll deal with or study about the various circumstances where we can apply this factor and understand the variation between an offer and an invitation to an offer. So the first part we are going to study is about quotation, that is catalog, and many more like that. The first point we're going to study in the fourth point is about quotation and catalog. So whenever you have already heard about the quotation and catalog, you might have heard about them. That let us take an example. For suppose you wanted to install solar panels on top of your house, then you'll approach a agency who will install the solar panels, any company like that who will install the solar panels to your house. So when you approach them, they'll come check your electricity bill and they will try to give you a quotation of how many solar panels you require for your house and what is the price or what is the cost for installing those, and all these things will be in that quotation. So it gives you an overall information about what is the cost or what is that you have to pay or you can expect to pay or you can expect to spend for doing that particular thing of installing the solar panels, for example. So that is what a quotation will say. And what is a catalog? So for example, if you visit any furniture store, they'll give you their catalog book or something like that, where all their furnitures will be placed in that book and along with the expected prices or prior prices will be set to you on request. So that is a catalog book. So both this quotation and catalog will give you an overall view of what is the price, but it is only an invitation to an offer, but it is not an offer. So it is invitation to an offer. If you are willing to accept that invitation to an offer, then it will be said to be as an offer. So basically the quotation and the catalog are an invitation to an offer. It is important to remember that this quotation and catalog, all these terms are invitation to an offer. To understand this, we can take an example of a case as well, that is Harvela versus Fassi. So in this case, there is an exchange of 3 telegrams. So what had happened? There are 2 people, A and B. So there was the first telegram which went from A to B. So what had that telegram told? So in that telegram, the A, that is Harvey, has sent a telegram to Fassi, who is B. So what he has asked? He has asked that if B is willing to sell his bumper hall pen and also asked for the lowest cash price. So he has asked the lowest price for that thing, and is he willing to sell this bumper hall pen? So this is the first telegram which A has sent to B, which Harvey has sent to Fassi. So in reply to this first telegram, Fassi has sent a reply. In reply to this telegram, he has told that the lowest cash price for this item is 900 pounds. So lowest price is 900 pounds is what Facey has replied to Harvey. So after this is the first telegram and this is the second telegram. In the first one, he has asked if he is willing to sell in the lowest cost price, and to this B has answered that the lowest price is 900 pounds. So to this, in reply to this, again A has sent a telegram to B saying that we agree to buy it, we agree to buy this for 900 pounds. So this is the third telegram. So these are all the telegrams which had happened between A and B. So what had happened? To this third one, Facey has not replied for the third one. So for this, Harvey has filed a case saying that there is a breach of contract which has happened. So he has said that there is a breach of contract. But you can see that whatever A has asked, that is he willing to sell this bumper hall pen, then Facey has not replied for that question itself. So he has just told the lowest price for that item, but he had not told if he is willing to sell that for that price or is he willing to sell or not in the first place. So you cannot say it is breach of contract until and unless B has accepted, because you have sent an invitation to an offer but the other person has not accepted to convert that invitation to convert that invitation into an offer. So he has only answered about the lowest price. So that does not mean that if you are willing to pay 900, you have to sell that thing or else it is a breach of contract. So this is the one example, and the next one is, next case you can see that is in between Macpherson versus Appanna. So what happened in this is the plaintiff has made an offer to the agent of the defendant to purchase the defendant's building for a particular price. So what had happened? You can again understand that has A and B, and A is the plaintiff, D is the defendant. You have to defend to what is argued on him. So what had happened? So this A has made an offer with the agent of B that he wanted to purchase the defendant's building for 6,000 rupees. So a particular building is there and A wanted to purchase this B's building for 6,000 rupees, and he has made an offer to the agent. So what had happened? Then in response to this request of the agent, the defendant, that is the B, has told that he will not sell his property for a cost which is less than 10,000 rupees. So basically A wanted to buy that building for 6,000, but B has confirmed that he will not sell this for less than 10,000. So this person A has accepted that he will pay 10,000 for that building, but the defendant has sold that building for someone else for a higher price. So he has basically sold that for a higher price to another person but not for A. So A has accepted to pay 10,000 for that. So when he has approached the court has told that he had only told that he won't give it for less than 10,000. That will not mean that he is willing to give that for 10,000. So it is negotiable and he will not give for less than 10,000 is what B has told. So A has said that he will give 10,000, but B has sold that for a higher price to someone else. So he has the right to sell as per his wish, because he has not said that he will sell the house for 10,000 only. It is his wish whether to sell it for more or less. So it is only an invitation to an offer, but it is not an offer, and therefore there is no breach of contract in this whole matter. So with this, we'll move on and study in detail about voluntary retirement scheme. Voluntary retirement scheme. So the SBI has introduced the voluntary retirement scheme and told that once the employee has submitted his application for the voluntary retirement scheme, he cannot withdraw the application. So when an employee has provided his application about this voluntary retirement scheme, he cannot go back from that thing. So this is what the State Bank of India has framed in its rules for the voluntary retirement scheme. So for this, Supreme Court has told that if once the application is accepted, then they cannot take back their application. So they cannot withdraw their decision once the application is accepted. But if, even though they have submitted the application, but the application was not accepted, then they can withdraw. So basically the rules were like, once you submitted the application, you cannot withdraw, whether it's accepted or not. But Supreme Court has told that even though they have submitted the application, if it is not accepted, then they can withdraw their application before its acceptance. So it is important to note this point about voluntary retirement schemes. So with this, we have completed the first part of the fourth characteristic, that is about the quotations and catalogue. Now we'll study about the auction cases. So in the next part, in the part B, we'll be studying about auction cases. What is an auction? So an auction is the sale by public competition. So you will know that whenever there is auction, there will be a competition among the people itself. So auction is sale by public competition. So whenever anyone asks what is an auction, so auction is a sale by public competition. So whenever you get the auction cases about auction, then there will be three questions which will be normally arise in the cases of auction. So what are the three questions which arise in the auction cases? The first question is whether an auctioneer, after announcing the sale by auction, can withdraw the article from the sale. So auctioneer is the person who is conducting the auction. So auctioneer announced sale, can they withdraw? So once the auctioneer has told that I am going to keep this particular item for auction, and can he withdraw after he has told that he'll keep that article for auction? That is the first question. And the second question is whether a bidder, after making a bid at an auction, can retract his bid before the fall of the hammer. So before the fall of hammer, can the bidder, that is the person who is participating in the auction, can withdraw his or her bid? The first question is whether the auctioneer can withdraw his article from auction, and the second question is before the fall of the hammer, can the person who is announcing his bid can withdraw from his bid? And the next question is that the auctioneer can refuse the knockdown. So for suppose a particular item has attained its highest price and nobody is willing to give anything more than that, can the auctioneer refuse to give that article to the highest person who has said for that article? So suppose an article has got 100 rupees in the auction. Can the auctioneer say that I'll not give this article for 100 rupees for this person, or he have to accept whatever the highest price which has come up in the auction? So these are the three questions which will arise when there are problems with auction. So we'll see one by one. So starting with the first question. So the first question, we can actually see the answer with an example of a case, that is Harris versus Nickerson's case. So what had happened? Basically, a person X has made an advertisement saying that he is keeping his furniture, a particular furniture, for auction, and he has specified a particular place and a certain period of time for the auction. So he has placed an advertisement that he will be keeping his auction of particular furniture for auction, and he has also told the place and time for this auction. So what had happened? After seeing the advertisement, Y has planned and went to the place and where the auction is said to be conducted. So when he has reached the place where he had said that the auction is to be conducted, he found that the article for the auction is not there because the auctioneer is not interested to put that article for auction anymore. So for this, Y has went to the court saying that there was a breach of contract because he told that he wanted to keep his furniture for auction, and he has specified the time and place, and I went there placing all the transport charges, went there to purchase that furniture, but when I went there, they told that it was not under auction. So I need to have my damages paid for my loss of transport and all these things. So when court has heard this thing, they have told that the advertisement which is provided for that particular auction of the furniture is only an invitation to an offer. It is only an invitation to an offer, and it is not an offer itself. So it is only an invitation to an offer. So it is not an offer, and so there is no breach of contract. So when there is an offer only, there is a breach of contract. When there is only an invitation to an offer. So such things like these advertisements about the auctions are only invitation, and there is no breach of contract in this particular situation, is what it is understood. So with this, we can see that a particular furniture can be withdrawn from the bid if the auctioneer wants it not to be auctioned anymore. So with this, we have completed the first question, that is, an auctioneer, after he has announced a sale, can withdraw that particular thing from the auction. So it is accepted. Next question is, before the fall of the hammer, can the bidder withdraw his or her bid? So for this also we can see with the example as well, that the case of Pani versus Cave. So what happened? A particular article was at auction, and the first person has made a bid for 40 pounds for that article, but before the fall of the hammer, so the hammer was not hit, but before the fall of the hammer, he has retracted from his bid, and what had happened? That later the same person has purchased the article for 30 pounds. So for this, the person who has done the auctioneer has approached the court and told that he had a loss of 10 pounds here because the same person has already said 40 pounds for that article, but later after retracting his bid, he has again purchased the same article for 30 pounds. So there was a loss of 10 pounds, so he has asked for the loss of 10 pounds. When he has approached the court has told that before the hit of the hammer, it is acceptable to retract from his bid. So it is valid that his first bid was retracted, and the second one he has got for 30 pounds, and this is right to do such a thing. So with this, we have got the answer to the second question as well. That is, it can be done. So it is a right of this person who is participating in the auction to withdraw before the hit of the hammer. So next, the third question is whether the auctioneer can refuse the knockdown to the highest bidder or not. So basically, before answering this question, we need to note that an auction can be of two types. That is, an auction can be done with reserve or an auction can be done without reserve. So when an auction is performed with reserve, that means that the rights will be in the hands of the auctioneer itself. So if the highest bidded price is not equal to or is not satisfactory to the auctioneer, then he can buy the article himself. So in with reserve auctions, this thing is possible, that if the highest bidded price is not satisfactory to the auctioneer, he can buy it for himself. But in auction without reserve, whatever the highest bid has come, he have to accept for that auction, because it is without reserve. So whether the price is equal to the price of the article or lower than the price of the article, whatever the highest price is, the auctioneer has to accept and sell his article for that particular price which is stated in the highest bid. So there is variation in between with reserve and without reserve. So auctions can be with reserve and without reserve, and this particular question can be answered based on the kind of the auction they are performing. So if the auction is with reserve, then they can refuse the knockdown. But if it is without the reserve, then they have to accept the knockdown. So for this we can see a case as well, that is the case of Marlowe versus Harrison. So in this, the auctioneer wanted to sell his mare, and the plaintiff has bidded for 60 guineas, which is their currency, and the next person, another person, has bidded for 61. So this person, the plaintiff, has bidded for 60 guineas, but the other person has bidded for 61. So this plaintiff has realized that the other person is the person who is conducting the auction itself. So he has approached the court, and the court has told that that auction was happening without reserve. So that auction was happening without reserve. So there is no right for the auctioneer to participate in this, because he has to accept to whatever the highest bid has come. So 60 guineas is the price which is the highest bid, and therefore he has to sell that mare to the plaintiff for 60 guineas itself. So here in this without reserve thing, the auctioneer cannot buy his article. So it is without reserve. So if that auction is with reserve, then he might have had the opportunity to buy that for himself. So that is the variation between auctions with reserve and without reserve. So the facility of the auctioneer to refuse the knockdown will depend on the kind of auction they are doing in that for that particular article. After auction cases, we will be studying about the tender cases. So a tender notification is to invite the tenders, is an invitation to an offer, and the submission of a tender in response to such a notification is an offer. So basically, why are tenders placed? So suppose there is a government property, suppose there is a hotel kind of thing, and they wanted to privatize that. Then they will issue a notification for tenders, and the tenderers, that is the people who are participating in this tender, will submit their applications for this particular thing, and they will quote their price, for what price they wanted to take that for lease or in any purpose which is mentioned in the notification. So the notification which is given by the government agency is known as an invitation to an offer, and whatever these tenders will submit in their application is the offer. So the notification, that tender notification is invitation to an offer, and the tender is an offer. So we have already seen that invitation to an offer cannot be converted into a contract, but an offer can be converted into a contract. So we'll see one case, that is Shri Durga Saw versus the state of Orissa. So in this case, the government of Odisha has held in an auction on this particular date for the purpose of leasing the forest copse. So they have conducted an auction, and that means they have given a tender notification. So one of the person has submitted the tender application, and also a 10% security deposit as well, along with the application which he has submitted. But the notification was for 1 lakh rupees, approximately it is worth 1 lakh value of the bid, and he has paid a 10% security deposit. What has happened was, he has withdrawn his bid before its acceptance. So even before his application was accepted, he has withdrawn his bid. So what has happened? The state of Orissa, the particular department, has sanctioned it to this particular person. Even though he has withdrawn his bid, they said that it is not acceptable because you already submitted and you cannot withdraw, and so that particular thing, whatever you have done, that was successfully provided to this person A. So when he has approached the court, he has filed a writ petition, and the court has said that yes, this particular person has the right to withdraw his application before its acceptance. So he is not liable to take that offer. So here we can see that even before its acceptance, he can withdraw his application. And then the next case is Spencer versus Harding. So in this, what had happened was, the defendant has sent out a circular calling for tenders from intending purchases of a certain stock in trade. So he has basically given a notification for these people. So what had happened? The plaintiff has given the highest amount. So he has quoted the highest bid. But the defendant was not able, he has failed to sell the stock to the plaintiff. So when the plaintiff has filed the case, they have told that the calling for tenders is only an invitation to an offer and not an offer in itself. So it is not a contract, and therefore you cannot claim that he have to give the stocks to the plaintiff, because he only has given an invitation to an offer, and whatever the bid they have done is the offer, and it is for the defendant whether to accept that particular offer or not. So with these cases, we can clearly understand that an offer can become a contract, and an invitation to offer cannot become a contract. So an offer can become a contract, but an invitation to offer cannot become a contract. So let's see a next example, that is the case Harvela Invest Ltd versus Royal Trust. In this case, a company has called out for the tenders for the purchase of shares. So a company has called out for tenders for the purchase of sales to both X and Y. So they have actually sent offers for both X and Y. They have invited offers from both X and Y for the purchase of their shares. So here they have done the invitation to an offer. So X has offered to pay these many dollars for the shares, and Y has offered to pay these many dollars for those shares, and if this particular amount was less than what X has offered, then he is willing to give $1 lakh more than what X has said. So X has clearly stated that I wanted to give a particular amount for your shares, but Y has told a particular amount and also said that if this amount was less, he would pay $1 lakh more than what X has said he would give for those shares. So the question here is, who should get the shares? Is it the one X should get or Y should get? Because X has quoted a higher price, but Y has told he is willing to give still higher price more than X if whatever he has quoted is less. So then, with the interference of the House of Lords, they have told that the invitation to an offer was for fixed offers. It was for fixed amount. And so, whatever X has said is highest, so the shares should go rightfully to X because the invitation was for fixed offers. And Y's offer was not fixed. It was not static. But X offer was static. So, the shares should rightfully belong, and the verdict was given that they should go in favor of X. So after this, the tender can also be as a standing offer. So a tender can also be as a standing offer. So what is a standing offer in the sense? So there will be an agreement in between both the parties. Both the parties will have an agreement for a period of time for a certain article or anything related to their contract. So this contract will come into place every time they place an order. Suppose there is a contract between these two people that this person should supply soaps to this person whenever he has ordered. So every time this person will place an order to this person, there will be a contract which is arising, and once the order is placed, this person cannot revoke from his order. But if this person has not placed the order, then this person can refuse or come out of this offer, come out of the standing offer. So we'll understand this with an example. So what is the case? It is Great Northern Railway versus Witham. So what had happened? So the plaintiff company has called, out for the tenders for the supply of stores, and the defendant was the one who has won in this particular tender. His offer was accepted. So this company started to place orders from time to time to the defendant. But once after placing the order, this person, the defendant, has refused to supply the stores, for the supply of stores. So when the plaintiff has approached court, then court has clarified that once an order is placed, it cannot be revoked. It cannot be refused to be accepted. So whenever in these standing offers, if an order is placed, that means that there has been a contact between these two people. But you can refuse it before the order is placed. So if the order is not placed, then they can come out of this contract, come out of this standing offer. But when the order is placed, they cannot come out of this. So with the term standing offer, we can understand that if once the tender is placed for the supply of these stores, then it is that their offer is there available every time, and the offer will be converted into a contract whenever an order is placed. So that is the meaning of the standing offer. And if the order is placed, there is a contract, and if you won't execute that particular contract, then there will be breach of contract and you have to pay for the plaintiff. So here also the defendant was asked to pay for the plaintiff. So in the next case, also you can understand this example more clearly. That is in the case of Union of India versus Madala. So what had happened is that the government has invited tenders for the supply of jaggery. So this person's tender was accepted, and they have said that he have to supply 14,000, which is some unit for the calculation of jaggery, during a period from February to March, which was in 1948. So what had happened? The government has placed orders on 16 to 1948 for 3,500 mounds of jaggery, and they also placed an offer on 1st of March for another 3,500 mounds. But what they have done was the orders were cancelled on 8/3/1948. So when the plaintiff, has approached the court, then court has told that once you have placed the orders, it becomes a contract, and you cannot refuse your order. You cannot cancel your order once the order is placed, because this particular thing is a standing offer. You can order this much quantity of jaggery from the period of February to March. So you have already placed your orders, and so it has become a contract, and you cannot come out of that contract, and so you can't cancel these offers, is what the court has said in its verdict. So with this, we have completed the part that is tenders, along with the tenders which act as standing offer. So moving on, the next part is the railway cases. So let us understand this with the case, that is Denton versus Great Northern Railway Company. So a railway company has issued a timetable about what are the trains and what is the time it is going to start, and from where to where will that particular train go. And after issuing the timetable, this particular person went to where he can buy the ticket and asked for a train X. But he found out that the train X is no longer functioning and it was stopped. So that particular train was mentioned in the timetable which was published by this particular railway company. So he has went and approached the court that this railway timetable is an offer, asked for the ticket, then it will become a contract, and they did not provide me with the ticket, and therefore there is a breach of contract and they have to pay for the damages which are caused. Because in his suit he has said that timetable is an offer in itself, and when I went and asked for the ticket, it is an contract and there was a breach of contract. So for this argument he was given the damages. But for Lord Campbell and Whitman JJ, they have told that whatever the timetable was issued by this railway company is only an invitation to an offer. It is not an offer in itself. Whatever the timetable they have issued is an invitation to an offer, and if you go and ask for the ticket, then it will show your willingness. So it is your offer, and when they issue the ticket to you, then it will become a contract. And they've also raised a question that for suppose you went to the counter and asked for a ticket but refused to buy, then what is it? Is it a breach of contract? Because this person has argued that this is an offer in itself and I went and asked for the ticket, it became a contract. But let us suppose this person has not purchased that particular ticket, then will it be a breach of contract? No, because whatever the timetable which is issued is only an invitation to an offer. It is not an offer in itself. So this is what we can understand from this particular railway cases. So moving on to the next E part, that is self-service shops. So in this, whatever the goods which are having a price tag, then whatever the price tag is attached is only an invitation to an offer. The price tag is not an offer in itself. So previously there was a notation, there was a thinking by the people that for suppose there is a self-service shop and whatever the item which is placed in the shop will become an offer, and if the particular customer will go and pick up that item, it will become an contract, and if they were not able to sell that item to this person, it will become a breach of contract. But this notion was changed by the words of Lord Gordon, who was a Chief Justice, when he has told that whatever is placed in a self-service shop, whatever the article is placed, it will only be an invitation to an offer. It is not an offer. And when the customer will go and pick up that article, it will become an offer. So basically the article with the price tag is an invitation to an offer, and this customer, when he goes and picks up the article, it will become an offer, and when this person will pay the money and buy that product, it will become a contract between both of them which is fulfilled because his offer was accepted by the person who is running the self-service shop. So with this we can understand that the goods with the price tag is only an invitation to an offer and not an offer in itself. So with this we have completed the self-service shops as well. The next part after self-service shops, that is the negotiation details. So in this it is important to remember that negotiations are not considered as an offer. So whenever there are negotiations between two people, it will not give rise to any offer. It is just like an invitation to an offer, that if one person says a particular rate and the other person will say no, not this or something like that, and there is a negotiation between two people, then it will not become an offer, and therefore when the other person accepts it, it will not become a contract. So negotiation details will not create an offer.